Want to take a break? That's fine. I'll just keep talking. Speaking about restoration of rights, in the South Carolina recently enacted 2015 domestic violence provisions pertaining to firearms, 162530 F2. They specifically state, following the period of time established in the statute, if the person requests in writing, so that was the 10 years or 3 years, depending on which version of domestic violence you were charged with. Following that period, if the person requests in writing, SLED shall notify the National Instant Criminal Background Check System that the state restored the person's right, basically the owner of possessed firearm or ammunition, and shall request immediate removal of the person's name to whom the restrictions continue containing that section apply. So I actually had that case, and they told me I was the first person to exercise that provision of the statute. What happened was I had somebody who was they were charged with old CDV, criminal domestic violence, had the case dismissed, had an expungement done, but the big people at the time were taking the position that, well, expungements in South Carolina since a certain year are a little different because they're still maintaining somewhere. It's not a complete destruction of record. Somebody maintains a copy somewhere. So I got with Schlein, and I said, well, I recognize that this isn't this new statute, it's not pursuant to this new statute, but, you know, the spirit of the law, he did have his case expunged. So I got them to actually go advocate for me, and they look it up with the next people, and he got a letter, my client got a letter, his rights were restored, and he could go buy a gun. But before I got the letter, I got a phone call from Schlein saying, "Now your client is good to go. Go buy that gun. And if you want the CWP, let me know, and I'll make sure that he's good to go." So we did that. Okay, pocket. Oh boy, got my hands full here. All right, but that's a good thing, because here we have the federal statute, which is a lifetime ban, basically an indefinite ban, of course, except for an expungement or a pardon. But now you have the state statute that says we're limiting what constitutes a conviction under state law to a 10-year or 3-year period, no matter what the circumstances are. So unless there's another reason for the person to be prohibited, like convicted felon, convicted of something else, after 10 years or after 3 years, even if he was convicted, or she, that person can apply to SLED to have them notify NICS that their rights are restored. Now, I say I had the first case, but it didn't, it ended where it ended. You don't know whether the government would take a contrary position and say, well, wait a minute, we still take the position that they were convicted of a misdemeanor crime of domestic violence or something that has those elements, so we're not going to, that's still waiting to play out. But at least it's there, and it's nice to know about that. But again, this just illustrates the back and forth that went on in the General Assembly about passing that law in the first place, and kind of like when they went from 0.10 to to 0.08 with the DUI stat. There was a lot of compromise and back and forth, and later on they got more restricted. But there's a lot of stuff, a lot of competing interests. So I'll just point that out. And then we talked about expungements a little bit already. But you got a client that's charged with domestic violence. The statute specifically allows for certain the lesser of the domestic violence violations. I think it's the 3rd degree one. Specifically allows for them to go to PTI. because it's the solicitor's PTI program and it's discretionary who they accept, but by statute, they're allowed to go to PTI if they qualify to go in. So if you go to PTI and you get a non-conviction, well, you've not been convicted of a misdemeanor crime, so that's another way to handle it. It could be diverted. Of course, we all know the Supreme Court has says only the solicitor's office can run a pretrial diversionary program. The old way we could get things deferred. And now with these cases being handled in General Sessions Court, it is going to be the solicitor. It's not going to be magistrates and working it out with law enforcement anymore, like we used to do sometimes. Sometimes you're going to run into a prosecutor or somebody who specifically wants your client to have that firearms prohibition for whatever reason. We specifically want, I've had that in the past, we specifically want the firearms disability for your client. So they're not going to be too willing to bargain on that. You're just going to have to deal with it. All right. So much for the crime of domestic violence, but it doesn't end there. There's another section of federal law that is 922G8. 922G9 prohibits persons convicted of a misdemeanor crime of domestic violence from owning or possessing firearms or ammunition. But subsection 8 prohibits people who are subject to a restraining order prohibiting them from harming or threatening harm to an intimate partner or child thereof. So that's another restriction, that's another prohibition if you're filling out the federal firearms form. Now, where do we get that? Well, we have the Protection from Domestic Abuse Act. This is something that came into place several years ago, and I've outlined it, what we need to know, I guess, for this discussion in the handout. Sometimes when somebody gets charged with domestic violence, they're also going to be subjected to a an action for a restraining order. The police department or the prosecutor's office is going to have a victim's advocate working for them. They're going to not practice law without a license, but they're going to tell the person that you can go to the family court, or in some cases the magistrate's court, and you can apply, you can petition free of charge, they have the forms there, for a restraining order, an order of protection. Anybody not familiar with that? Okay. Well, to get convicted of domestic violence, the standard is proof beyond a reasonable doubt. In order to get a restraining order, it's proof by the more likely than not standard, preponderance of the evidence, the much lesser standard of proof. That's in family court. Depending on whether it's an emergency or not, if it's an emergency, you could get served the night before, or your client can get served the night before, 8 o'clock at night, for a hearing the next morning, and not even have an opportunity to get a lawyer before being subjected to a hearing for a restraining order. Well, you might wonder about the due process in that. Again, I'm not making an opinion here about the propriety of it. There was a reason why that statute was enacted, and maybe there are some cases that anybody would agree some relief is needed. But without me making a judgment, I'm just telling you what the law is on that. Now, I've had that case that I was talking about where the person was forced to go to let's call it trial without a lawyer for a hearing on an order of protection. Got served that evening, the next morning goes to court. The judge counseled the petitioner. Did they did they want a continuance? Were they ready to go forward? After some hesitation, yes, they were ready to go forward. The person who was our client, who became our client later, said, well, I'd like a continuance. I'd like, I'm not ready to go forward. Didn't want to consider that. And then they asked the petitioner, well, do you need time to get a lawyer? Do you want to get a lawyer for the hearing? No, I'll go. I'm ready. Well, I'd like a lawyer. I'd like a continuance to get a lawyer. Well, no, overruled. The statute doesn't allow for that. So, went forward with a hearing, and of course, anything you say, you have a right to take the fifth at a trial, right, for a criminal case, but there's no right to take a fifth in a civil case. Or at least you can take the fifth. I mean, yes, you always have that right, but you don't have a right to refuse to testify. And if you don't testify, you don't answer questions, and anything that you take the fifth on, the family court can draw an adverse inference. They can assign an adverse inference to that the answer would have been, detrimental to your legal interests. So we got the case later, and we took it up on appeal. And the ruling from the Supreme Court was that, and that was always a bone of contention for me anyway. I think I'd written about it, I talked about it, I'd written emails about it, hadn't really published anything on it, but the Supreme Court finally, that was Moore versus Moore, it's in your handout, that because of the purpose of what the hearing was for, if it's an emergency hearing, where it was held within the 24 to 48 hour period, well, then the hearing can go forward, and yes, all those restrictions would apply, but the fact that the person was, I'm going to say convicted, that's not really the right word, but for our understanding, they were found that there was some abuse or threat of harm, and that the order of protection should be issued. The Supreme Court said that if it was the emergency hearing and the person was denied the right to the attorney, didn't have the counsel, you couldn't use any findings at that hearing for any other legal purpose, any other subsequent legal proceeding was the words that they used. If it was the hearing that was held within 15 days where the person did have an opportunity to get a lawyer, then obviously you probably could. But if it was the emergency hearing, like this was the case, they could still go forward, hold a hearing, issue the order of protection to protect the person from harm where they found there was a threat, but you couldn't use that finding against them later. Because what we would find later on when we went to divorce, in final hearing, the judge would call the lawyers into conference, and there's a lawyer here that was on a case like that. He's in here in this room. I'm not going to call it out, but judge, well, Henry, your client is a wife beater. He can't have custody because it was a finding against him at the order of protection. Wife beater was basically, it was a loose term. It wasn't really a legal term, but when you're in the chamber, everybody's talking informally. Basically, I'm being told that, and I had another lawyer, my senior partner was there with me, Mr. Cummings. We're being told that we're not going to win custody, probably, if we go to trial. Of course, nobody's telling us what the finding is really going to be at a trial. We'll have to hear the evidence, but you know how it is in chambers. So it's a case basically that, knowing that, do we want to go back out and settle, talk settlement with the other lawyer about how that case was going to be resolved. It ended up in a joint custody case, but that's not really the subject here. Okay, but orders of protection, they have to make that finding that the person, there was a credible, either harmed or threatened harm to the intimate partner, domestic partner, or child thereof. That has to be in the order, and the judge has to find that by this order you're prohibited from owning or possessing firearms and ammunition, and they notify the sheriff and they put that in the computer that this finding was made, and so that's out there. After it expires, these orders of protection, they're good for 6 months to a year, they can, they can be a petition for renewal. If you get if there's subsequently a regular domestic case, the order, and an order is issued, a temporary order or a final order, the order of protection is no longer in effect. But any restraining orders that were in that can be carried over into the temporary or final decree in the regular domestic action. We'll talk about that in a minute. Because you probably wonder, well, what's the effect of them then? Good question. All right. I'm going to skip the part about stalking and harassment and permanent restraining orders, which was in the second handout, for just a second, and go over to the restraining orders in regular domestic cases. Okay. Does anybody here do divorce law? Okay. Has anybody in here themselves been through a divorce or something like that and cares to admit it? All right. I'm a 2-time loser. My boss is a 4-time loser. All right. If you do divorce law or you've been through a divorce, you probably know that our state code allows for a judge to issue restraining orders in domestic cases, restraining one or both parties from harming, harassing, or interfering with the peaceful enjoyment of life of the other, or threatening the other person. That's the wording that tends to be in those orders. It doesn't have to be a finding of harm. It doesn't have to be a threat of harm. It doesn't have to be a history. The statute allows for that to be issued on a temporary basis while the litigation is pending, or on a permanent basis. And most lawyers who do domestic law will put those in the pleadings, pleading for a restraining order. We want this one to be restrained from that one. And then they usually end up agreeing to mutual restraining orders. Okay, well, I didn't used to, I never really thought about that. Then another lawyer, a very senior lawyer who's still practicing out of Monk's Corner, taught me something. He said, well, Henry, we always put, when we do those restraining orders, we always put in there that the court makes no finding of any domestic abuse. There's no history of domestic abuse, and this is just a mutual civil restraining order only, and not one issued under any Protection from Domestic Abuse Act, stalking or harassment statute, or for purposes of any state or federal firearms laws, or the Federal Firearms Transaction Record Form 4473, or any forms that become its successors. I've used that language so much I kind of remember it. People ask me, what's that language that you put in there? And I send it to them. Can you email that to me? Be happy to. Why? Because that language, thank you. That language sounds a lot like the language that's prohibited, but that's implicated by the federal statute, subsection 8, 922G8, that says anybody who's restrained from threatening or harming an intimate partner or child thereof is a prohibited person. So what if somebody, those divorce decrees are temporary, they don't normally go into the sheriff's office computer or anything like that, but what if somebody came to the attention of law enforcement for some reason, and somebody starts saying, oh, wait a minute, there's this restraining order in the divorce decree. Is he or she allowed to, hang on a second. Is he or she allowed to have a firearm? And I did have a case where there was some history there of something, and even though it was not an order of protection hearing, when we talked to the judge about it, the judge says, in this case, I am going to make a finding that this is an order for prohibiting that, and that judge made a specific finding and said, I find that this does apply. I'm going to allow him to apply. He can petition back, and I think he gave me a time period like 6 months or a year or something like that to have it removed, but he made a finding then that that did apply, even though that was just a regular domestic case. So I'm going to give the mic to Mark in just a second. I just want to punctuate that by saying I think it's a safe bet that when you do these orders, if you might want to get some agreement to put some kind of language in it, some kind of cautionary language, so that it doesn't get misconstrued later by anybody else. And stalking and harassment, basically permanent restraining orders, unless that language is in there that it is a threat of harm to an intimate partner or child thereof, or that was the basis for the restraining order, then I think you're probably okay on that, because our state code even says that while permanent restraining orders are enforceable like an order of protection would be, they are not orders of protection for purposes of the state prohibition against firearms laws. Mark, you have a...
Well, I've heard that there's some magistrates in the room. Are there? Okay, so the magistrates have a bench checklist that they check. They fill out boxes for restraining orders and protection orders. And one of those boxes is this a firearm prohibitive? This is a firearm prohibitive order of protection. And that checklist, if you check that box and it's firearms prohibitive, that form is part of what gets conveyed to the sheriff's office to go to the clerk who's working in communications, who enters the record into NCIC as to whether this person is restricted from possessing firearms or not. And that, being in NCIC, is what NICS looks at to say if the person can purchase, and what is also communicated back to a deputy on the street about whether that person is allowed to have that firearm. So it's not just the language that the attorneys and the magistrate agree to put in it, it's whether that box gets checked by the magistrate.
So, yes, make sure that these form orders, make sure that the box is not checked if it's not supposed to be checked, because some magistrates will, present company accepted, and all due respect to everybody, every judge everywhere, anytime, some judges will just check every box, without really a basis for it. If a box is checked and there may not be a basis for it, then you've got to go back and, well, why is it checked? Should it have been checked? So it's easier to do these things beforehand than when you have to go back and litigate them later. There's more materials in there than I could possibly talk about in an hour, and I don't want to tie everybody up waiting to ask me questions while we hold people up for lunch. So if you want to ask me a question, I'm going to be here all day. You can see me right after I turn the mic over to Steve, or anytime during the day, and I'll be happy to talk to you. Because whatever you want to hear about, that's what I want to talk about. More than what I wrote down. I want to talk about what you want to hear about. So thank you.
Thank you, Henry.